Madam Court Reporter, did you get everyone to identify themselves?
Oh,
Sorry, Your Honor, I just got online.
Okay. I'm having trouble getting the internet to work at my hotel, so I'm on my phone.
Your Honor, good morning. This is William Sykes. If you'd like, I can introduce the folks on behalf of the state.
That would be lovely, Mr. Sykes.
All right, thank you, Your Honor. So Will Sykes from Cloggett and Sykes. Also from my firm, we have Richard High. And then from the Nachawati Law Group, we have Brian McMath, Phil Carlson, Matt Bush, and Brian Moore. From the law firm of Moore, Sullivan, Lemkel, and Terzo, we have Will Lemkel and Christopher Terzo. From the Attorney General's office, we have Mark Kruger and Raquel Fogel. I believe that's everyone for the state. Hopefully that's enough.
Thank you, Mr. Sykes. Mr. Sneed, can you introduce your team, please?
Yes, Your Honor. I'm David Sneed from the firm of Covington and Burling on behalf of Meta, and with me on the call are Tammy Peterson, as well as Dan Waite, as well as Julie Meyer, all on behalf of Meta.
Thank you. I have one issue before I start. And Mr. Sneed, thank you for sending me the CMO. I had a chance to read it this morning. One issue to raise related to the CMO. The state has asked me in my billing to identify which of the three cases each motion relates to, unless it relates to all. So if any of you file a motion that relates to one or the other of the cases, if you would please specify that under the title of your motion, as in this applies to case number, so I can accurately provide the information to the state for billing purposes.
We will do so, Your Honor.
Thank you. So you guys have an issue related to the extension for certain discovery requests that are pending, production of depositions from the MDL, and the issue about the pending motion to stay that I understand Judge Kishner has set for after the due date of the motion. So I got a chance to read both your emails that related to that and the conversations Mr. Sykes included in his. Who wants to start?
I'd be happy to start, given the request for extension that I think is the beginning launching point for this dispute that I think is happening. I view them to be two distinct entities. One is Meta's direct request to ask for more time to respond to the state's discovery request, and two, being the state's request for deposition transcripts from other jurisdictions to be produced in this case. And I have a rundown that I wanted to give on those two issues. One thing I'll just correct at the outset is that September 25th is the same date in terms of the time for the responses to the discovery request are due and the date of the hearing, and so it's not afterwards. But
okay.
But just to kind of provide some context and set the stage here, as I mentioned in our last hearing when discovery launched, we made a commitment, Meta made a commitment to produce the materials that were produced, the documents that were produced from the MDL to the Nevada AG. And we made that commitment to the state, we made that commitment to the court and to the special master, the special master in this case. And as soon as the PO was entered, we began doing so. I mentioned in our last hearing, we had accounted for 2 million of the documents of the 2.5 million documents that we were produced. And the last one would take a little bit more time. I mentioned that at our last hearing. We're on track to finish that. I'm pushing to kind of try to get that done over the next week so that that will be completely out and the final production will be out. And since the time of the last hearing, besides that work on the production, the parties have been litigating Meta's motion to stay, as you know, and you've run down the dates. That stay motion is essentially ripe. The only thing that's left is a hearing. So we are currently 9 days away from Judge Kishner hearing Meta's motion to stay. And the basis for that stay, and I'm not going to argue it, but it's very straightforward. It's essentially whether there's jurisdiction, personal jurisdiction over Meta, and the Nevada Supreme Court is considering that issue. And Meta's position is that it makes sense to let that proceeding in the appellate court take place before coming back and addressing further discovery in this case. And that's what's happened in other cases that are currently in the Nevada courts right now. They're stayed pending what's going on in appeals. So our position is the same should happen here. Now, in the papers for that motion to stay, the state has taken the position that Meta's MDL reproduction has been somehow improper. The state has stated that the Meta's document production, which was massive, as the state describes, were not required under any rule or pre-existing agreement, and that it was essentially done, and I'll quote, to delay this litigation and avoid a merits-based resolution of the state's PI motion. And we couldn't disagree with that anymore. We were surprised by the state taking the position that Meta should be acting as if there's a stay in place on discovery during the course of discovery. It was our understanding we made the commitment to the document production, and we were going to follow through on that. And that's what we've been doing. Now, on September 5th, as I previewed in our hearing last time, Meta reached out to the state to ask for a 30-day extension.
Counsel, can you take a breath, please?
Yes.
Thank you.
Okay, Mr. Sneed.
All right, I'll go a little slower. I apologize. This isn't the first time that reminder has been given to me. On September 5th, 2025, so 12 days ago, Meta reached out to the state, and we asked for a 30-day extension to the discovery timeframe to respond to their over 200 requests for production that they provided. We had previewed that request, given the breadth and volume of the state's request, and it would be extremely difficult for Meta to do the work necessary to comply with the requests by the 25th. In that request, we also explained that the state that Meta was currently moving to stay the case, and that a 30-day extension would make sense, and the parties would know whether the court was going to issue the stay or not. We underline that the deadline for discovery in this case, which is September 2026, would not be affected by that. And the state's response was that they would not agree to any extension unless Meta, by September 25th, produced all the depositions that have been taken in the litigation, which is what they've requested in their 12 requests in their second request for production. Now, as an initial matter, that brings us to having to come to you, because the state essentially said, we're not going to agree unless you do this, to ask for this extension of discovery. I don't think it's disputed the number and breadth of the requests, and I haven't heard from the state any response regarding the burdensome nature of Meta responding to such a large number of requests with so many different types of materials requested, including on issues that have not been produced or addressed in this litigation to this point. I haven't heard that in the state's correspondence. The only response we've gotten from the state is essentially, you have to give us the deposition transcripts. And to be clear, that those deposition transcripts are over 100 depositions that they're referring to, and they've requested, including of many witnesses who were not identified in the other party's Rule 16 initial disclosures. Now, so I think without talking about the deposition transcript issue, I think Meta just has a direct request to seek an extension for 30 days, given the state's unwillingness to agree to that. Now, I do want to address the state's requests for the deposition transcripts, which were mentioned previously. They've asked for them in two different ways now. The first being in their discovery requests, which are due on September 25th, and the second being in their Rule 16.1 disclosures, and arguing that we are obligated to produce all of them because of the Rule 16.1 disclosures. Those are two different kind of pathways for discovery, and I'll address each one of them briefly. First, on the discovery request, the deadline is September 25th. And while we've been clear that we have continued to do what we committed on the MDL reproduction, and we've been clear we will provide them written responses. The only thing that Meta has said to this point is that given several reasons, we're not going to be able to make the document production of deposition transcripts by September 25th. And that's including because of the ongoing work on the production we're doing, our pending motion for the stay, which we've talked about before, and the lengthy time frame for discovery coming up. We've given those reasons to the state. And the state is
Weren't
continuing.
you also discussing, though, a limitation related to the use of the deposition and taking further depositions before you produce them?
We asked for, before we had this dispute, what we asked before providing the deposition transcripts initially was we'd like to reach an agreement about limiting what can happen in this case in terms of further depositions and repeat depositions and depositions of the senior executives again. We've asked for that kind of agreement, and the state has said, no, we are not going to reach that agreement. And all we're going to do is abide by what the rules are here in Nevada for limits on discovery. So they have been unwilling to reach an agreement on limitations for depositions in this case. And they've been unwilling to give us an extension on our general discovery request overall so that we would have the time to be able to hash those issues out. Now, on Rule 16.1, I view the requirements of the rule quite differently from what they've requested. Their request is for all of the deposition transcripts taken in every jurisdiction with teen mental health cases. And they've listed all 10 of the states that are proceeding separately, the MDL and the JCCP in their discovery requests. Under Rule 16.1, what's obligated to be provided is a copy or a description by category and location of documents that we may use to support claims, and that includes witness statements. Nothing in here says that every deposition transcript for witnesses that are not even disclosed by either side are required to be produced to the other side under Rule 16.1. What we did offer to the state was providing information, a description of the deposition transcripts that are particularly identified by either side in this case, in the Rule 16.1 disclosures. And then we did so by providing the state a description of information, including the date that the depositions were taken on, including the jurisdiction that it was taken in, including whether there were multiple depositions taken or not. And the only thing that Meta has not committed to and does not commit to is a document production by September 25th. And if the state will not reach an agreement, we have to ask for an extension to be able to address the state's discovery request.
And just to be clear, Mr. Sneed, you are asking for that from me.
That is correct.
Okay, Mr. Sykes.
Thank you, Your Honor. A few things to address. First and foremost, no state has been entered in this case. And obviously the state vigorously opposes a state being entered in this case for a variety of reasons, but we're not here to litigate the state. So obviously I'm not going to do that now.
I'm sorry, counsel, there's some background noise.
I think that's me because I'm in the lobby of the hotel. Let me see if I can figure out how to turn my volume down. I'm going to mute me.
All right, thank you.
Okay, counsel, and counsel, please slow down. Thank you.
All right, will do. So we're not here to litigate the stay. Judge Kishner is going to handle that on the 25th, assuming she doesn't take it under advisement on that day and not even provide a ruling. So the stay has not been entered. Discovery is open, and we've been dealing with this issue with regard to the deposition transcripts for the better part of a year. And that's the context that matters in this case. And I won't even go back the entire year. I'll start with the early case conference. Meta asked the state to essentially agree not to take the depositions of Meta witnesses in this case, and to use the deposition transcripts in lieu of taking those depositions in this case. The state cannot agree to do that until we see the deposition transcripts. We need to know what was covered, how it was covered. We need to know what the claims and defenses are in those other cases, what the protective orders are, what the limitations are in discovery in those cases, because those may not exist in this case. We need to know what objections were lodged during the depositions, if they were cured during the deposition, if they're curable. There's a wide variety of things that the state needs to consider before it can reach an agreement with Meta not to take depositions of Meta witnesses in this case. And we've been asking for these transcripts since the beginning of discovery in this case, Judge, and we've been discussing these depositions for the better part of a year. And so when Meta came and asked for a 30-day extension, we said, okay, that's fine, but please produce the deposition transcripts that we've been discussing for several months. It'll allow the state to review them, to evaluate them. And then at that point, and this Mr. Sneed's representation on this was incorrect. At no point did we say we're never going to reach an agreement with you. What we specifically stated was we will enter into negotiations and we will have a good faith conferral once we see the transcripts. Because once we see the transcripts, then we can make an evaluation as to whether we can enter into that agreement not to take certain depositions or to limit certain depositions in this case, which the state is still prepared to enter negotiations in as long as we can see the transcripts that Meta is talking about. And that's all we want, Judge, is to see the transcripts. Now, Meta talks about the burdensome nature of our requests. There's 3 distinct written discovery requests that we sent. There is the second set of interrogatories, there is the second set of requests for production of documents, and there is the third set of requests for production of documents. The state's position is really simple. We're willing to grant the extension on the second set of interrogatories and the third set of requests for production of documents. That's the voluminous request. So long as Meta responds to the second set of requests for production of documents, which is specifically requesting the transcripts. There's only 12 requests there, Judge. It's not 200 requests. These transcripts are in Meta's possession. They're in Meta's control. I know he's stating that they may have listed out the depositions, and that happened fairly recently. The state, I believe, just received that list. But the list of depositions doesn't do us any good because we don't have access to those transcripts because of the protective orders entered in those cases. And so, Judge, all we're asking for is for them to produce the transcripts that they already have in their possession. These are transcripts they want us to use in lieu of taking certain depositions in this case. And I think it's only fair that the state be allowed to see the transcripts themselves so we can move this case along. That's the primary thrust of the state's position. And that's why we're asking for what we're asking for. Now, with regard to the 16.1 disclosures, Judge, as you know, they require the Meta to produce any documents that they intend to use in support of their claims or defenses. Well, if Meta intends to use any of the testimony from these transcripts, they should be producing them. And when I mean producing them, I mean providing us with a copy. Providing us with categories, again, doesn't do us any good because we don't have access to these transcripts. It's not like a published article that we can go out and pull from the internet. We can't do that. And so that's why we took the position we took. The only set of requests we're not willing to give an extension on is the 12 requests for production of documents for the depositions. Now, if Meta's taking the position that, hey, there's 100 of them and we can only produce half of them now, well, then let's have that discussion. And the state's willing to have that discussion. But to simply say we're not going to produce anything, even though they're within our possession and control by the 25th, when we've been formally discussing these transcripts since May 30th at the early case conference. And not only that, I sent an email, I believe it was back on the 5th, specifically asking that these transcripts be produced. And my email was ignored. And not only was it ignored, then then the follow-up email was, can we get a 30-day extension on all of the state's discovery requests? And so, Your Honor, we just want to move this case along. I think this is a fairly simple issue. We're willing to give the 30-day extension on the second set of requests for interrogatories and the third set of requests for production of documents. We do need Meta to respond to the second set of requests for production of documents for the transcripts. And if it's a situation where they can't produce all of them at once, we can discuss that. But to say that we can't produce a single transcript by September 25th just doesn't hold water, Your Honor. And if you have any questions, I'm happy to answer those. But we believe the transcripts need to be produced pursuant to NRCP 16.1 and our request for production of documents. And with that, Your Honor, I'll happy to answer any questions you have.
How long do you anticipate, Mr. Sykes, from the time that you receive the deposition transcripts for you to review them and make a determination whether you need to redepose or redepose for limited purposes any of those particular deponents?
Your Honor, based on Mr. Sneed's representation that this is, there's 100 depositions that might be responsive. This could take several weeks to go through all the depositions because I don't know how long these transcripts are. If there's 2-day depositions or day-long depositions and there's 100 of them, it could take quite a while. And that's the state's other concern. I mean, this is going to take us a while to get through.
Would it be fair to say that you can't make a decision on whether you're going to be able to meet the deposition deadline for next September until after you've looked at those deposition transcripts?
I think that's fair, Your Honor, because that will help the parties determine what depositions we need to take in this case, or probably more accurately, what depositions need to be limited in this case or restricted.
Okay, thank you. And Madam Court Reporter, I'm going to try and figure out how to mute myself again. Mr. Sykes, I appreciate you answering my questions. Mr. Sneed, you're back up.
Yes. So, Your Honor, a couple of things to say in terms of correcting my representation as an initial matter. I want to make sure that I am clear as to the representation I made as to the state refusing the request. It was not, as Mr. Sykes described, a refusal to consider these issues at all. It was a refusal to give us the extension, which I do understand to be the state's position and has been reflected in the state's position here. Now, as to Mr. Sykes' response, these are 12 requests. In terms of the discovery requests themselves, they are the first portion of the discovery process that's happening in this case. And we are working to complete the MDL reproduction that we have been working on and trying to get done, and we've done in a very expeditious manner. And our position regarding the deposition transcripts is not that it is impossible to produce one deposition transcript. It's that at the current stage of the case, in the procedural posture the case is in, with our ongoing production of the materials, all of which have been produced to all of those jurisdictions, with the pending motion to stay, which would stay discovery in the entire case, potentially, within 9 days and learning about that. And with the year that we have ahead of us toward the discovery deadline, where there will be a great deal of time for the state to review these and consider what depositions they're going to need or not. No, there's been no discussion at all, and I didn't anticipate any discussion at all, given the production that we're making at this point, about depositions and what the state is intending on depositions. It's our position that there is plenty of time to address these issues after we learn what the upshot is going to be regarding the pending motion to stay, as well as given that we have not treated this as a imposed stay from Meta's perspective. We have done our job producing the documents that we've provided, as well as updating our initial disclosures already once and preparing to do so again, providing them further information about these witnesses. I think we've been very prompt when it comes to discovery process in this case. And so our position is that we don't disagree that the state can and should review the deposition transcripts that we will produce in the discovery process in this case. The only thing that Meta has communicated was that we are not prepared to make the production of the materials by September 25th, as the state has required, to get an extension on the breadth of discovery requests that they have offered.
Mr. Sneed, can you summarize for me what you believe the status before the Nevada Supreme Court is?
Yes, Your Honor. The state had a deadline on Monday for their response to our paper seeking en banc reconsideration. The state requested and received an extension to that request so that they will be filing their response, I believe, on September 29th with Meta's reply brief on that request for en banc consideration due October 13th.
And Your Honor, I just wanted to add one thing with regard to timing, and I'll make it very brief. So with regard to the timing, another big concern we have here is one of the things the parties need to do as part of their early case conference, as part of the JCCR, is we're supposed to determine how many depositions we need to take, or if we at least need to modify the number of depositions that the rule provides. We are now some 4 months or close to 4 months after our early case conference, and the state can still not definitively answer that question because we still don't have these transcripts that we've been talking about for the better part of a year. And so I think delaying and kicking the can down the road and saying, well, we'll deal with this after a potential stay might be entered is not efficient. It's not the best use of the court's resources. It's not the best use of the party's resources. And frankly, if the case is stayed sometime this month or next month, I think it'd be the better use of the time for the state and the parties if we have the transcripts so we can start that review process.
Thank you. Given the current posture before the Nevada Supreme Court and the length of time the parties have been discussing the production of the deposition transcripts from the other cases, I am going to deny the request for an extension related to the second request for production that is pending, which is the deposition transcripts. Given the offer by the state to give you an extension as to the second set of interrogatories and third request for production, I'm going to grant that 30-day stay since they had offered it to you. Mr. Sykes, would you please prepare a recommendation and send it over to Mr. Sneed to review so you can take it to Judge Kishner, and then she can make a determination if she's going to stay and or give additional extensions to you, Mr. Sneed.
Thank you, Your Honor. Will do.
Anything else? Madam Court Reporter, you need any spellings?
No, but before we close out, if everyone could leave their firm name and in the chat, that would be great. I know one person did, but I haven't gotten it yet, so please don't close out yet.
All right, I'm going to have Mr. Sneed identify everybody who has participated and include their firm name, and then I'm going to have Mr. Sykes do the same thing. Good luck, Mr. Sneed.
It looks like everyone is putting their information into the chat, and I will copy and paste it out before we close. Just let me know when we're off the record.
All right, does anybody not added the information into the chat so I can close this up and go check into my hotel room? All right, you all have a wonderful day. Let me know if there's anything else I can do. I do have this particular time free most days, so let me know.
Thank you, Your Honor.
Thank you, Your Honor.
All right, have a nice day. Bye-bye.